Well, all right, everybody, we're going to get started here. My name is Chris Green. I'm the Executive Director of the Harvard Animal Law and Policy Program, and I'd like to thank the Harvard SALDEF for putting this event together, and thank our speaker, Stephen Wise, for joining us today. Steve is the founder of the Nonhuman Rights Project, and I first met Steve, I guess, 15 years ago when, after a six-year absence, I returned to Harvard Law School specifically to take the animal rights law course that Steve was teaching. And at the time, Harvard was only the 9th school to ever teach an animal law course, and it was the first time they ever had. And now I think there's 163 schools that have taught a course in animal law. And that sort of changed the course of my professional career. And since then, Steve and I have become close and colleagues and worked together on some things. And he's held a ton of different roles. His book, when we were taking the class, Rattling the Cage, came out. And many people think of Animal Liberation by Peter Singer as the foundational text of the modern animal rights movement. I feel that Rattling the Cage is sort of the foundational text of animal law, as helping it become identified and recognized as a distinct and valid field of its own. So with that, I will turn it over to Steve. Thank you so much.
Thank you. Thank you, Chris, for inviting me. And I always say, when I talk about Chris, I've taught for a lot of years. Chris was the best student I ever had. And then I'll tell you just one other fact about him, is that he took an incomplete in the class and spent a year working on his final paper, and it was, 450 pages long? Yes.
Pretty long.
Yes. It was more than 400 pages long. You don't forget something like that when you're a teacher. So, yes, so those are two interesting factoids about Chris. Well, thanks again for inviting me here. Let me start by just talking about something that I talked about in a TED Talk, which is really what the problem is with respect to the law and non-human animals. And the rest of my talk is really how the Nonhuman Rights Project is dealing with the problem. So the problem has been, as I've envisioned it, is that there is this legal wall that has existed between legal things on one hand side of the wall and legal persons on the other side of the wall. And a legal thing is invisible to the civil law. It doesn't count in law. It is essentially a slave to the master, who are those who are persons. And a thing in law means that it lacks the capacity for any sort of legal rights. And so on the other side of that wall are persons. All of us here are persons, and we count in law. We're visible to law. We are the masters to the slaves, who are the things. And most importantly, it means that we have the capacity for one or even an infinite number of legal rights. So today, as it's been every day, all non-human animals are on the thing side of that wall, which means they all lack the capacity for legal rights. On the other side of the wall are all human beings, and they have the capacity for legal rights. But this is just a snapshot of what it looks like today in 2017. If we went back, say, to England in 1770, all the non-human animals of the world would be on the thing side, but there would be many human beings that would also be there. Certainly black slaves were there, perhaps women were there, or the children might have been there at some time. Mentally ill folks might have been there. There are other human beings who are seen as legal things who really are bereft of legal rights, with slaves really being the greatest example. So a lot of the civil rights work, of the ensuing two and a half centuries was really to repeatedly punch a hole in the wall and be feeding the human beings who are on the thing side of the wall over to the person side of the wall. And so in 2017 now, we're all there. So the wall is permeable, and what we're really looking at is a process. But importantly, on the person side of the wall, there's always been entities who are not human beings. So while I don't have to tell people here at Harvard Law School that Citizens United case where corporations were given the First Amendment right to corrupt our elections, then that's something that lawyers have always known. Not that they had that right to corrupt elections, and someday perhaps they won't, but that corporations were persons. And they had been persons for a long time under the common law, and they've been persons for a long time under the 14th Amendment as well, I think since the Santa Clara Railroad case in the 1880s. But for a lot of people in the United States, it was their first realization that corporations were persons. But ships have been persons, partnerships are persons, and then perhaps closer to what we're litigating around is that in pre-independence India, courts had found that a Hindu idol was a person, that a mosque was a person. In 2000, the Indian Supreme Court found that the holy books of the Sikh religion is a person. New Zealand has really been pushing it forward. About 7 years ago, New Zealand designated a certain river, the Wanganui Iwi, as a person with the rights and duties of a person. It owned its own riverbed. And then last year, New Zealand designated a certain national park, as a person, which means it has the capacity for rights, and it also has the capacity for duties. Now, since the Nonhuman Rights Project began its work, there have been folks who've been filing lawsuits that are that really follow along the same track in Argentina. And in November of 2016, a court in Argentina found that a chimpanzee named Cecilia was a non-human person who had a certain kind of fundamental right, who was released from the Mendoza Zoo and sent to a sanctuary in Brazil. So that was really the first breakthrough of the sorts of arguments and the ideas that the Non-Human Rights Project has been writing about and been suing about for a long time. And so when you don't have personhood, you really have almost nothing at all. Even your most fundamental interests are not protected. And sometimes I talk to my students about using some kind of a metaphor. I'll use this one here today, so that if this bottle, if all the water drops of this bottle are legal rights, if I just pour them out, there's no container. Nobody has any legal rights. And what a person is the legal construction of a container that will hold the rights. So unless you're a rights container, and everyone in the room here is a rights container, but non-human animals are not rights containers, then once you are one, then the Non-Human Rights Project and others begin to struggle with the legislatures and with the courts around the issue of which of the millions and millions of rights that are in this container ought to apply to our non-human animal plaintiffs. So our fight right now, and has been for a long time, is over the construction of the container. Can a non-human animal be that rights container, be a legal person? And the first drop we've been arguing in our cases is that chimpanzees ought to have a fundamental right to bodily liberty that's protected by a common law writ of habeas corpus. So that's really what we did when we filed our first suits. We filed 3 suits in the first week of December 2013. And so we sought common law writs of habeas corpus in the state of New York, on behalf of chimpanzees. And what I want to talk about for the rest of the time is why we did these things, why we made these kinds of choices, and then what it means for the future of what we're doing, and also how the courts have responded to what we've done. So the first thing is that the writs that we filed, or the petitions we filed, were all under the common law. And the reason that we brought them under the common law was because the common law, which is really the heritage of all English-speaking judges, the Anglo-American heritage, the common law is inherently flexible. And it's intended to be flexible, and it's intended to be able to be used by judges to keep the common law fresh, to respond to scientific advances, changing public morality, and other sorts of changing public experience. And so the idea that all non-human animals are legal things is a common law idea. And so the judges, when we go in front of a judge, the judges are the descendants of those who made the common law. So we go in front of them and we say that you made the common law, meaning either you did, but most likely other judges before you a long time ago, made the common law, ruled that all non-human animals are legal things. And so we go to the judges and we argue that here are changing scientific facts, here are changing public morality, other sorts of public experience. We bring our policy arguments, our moral arguments in front of the courts and say, it's not only the fact that common law judges have the ability to change the common law, but that they have the duty to change the common law. That's why they're there. And so when they deal with the common law, it's not supposed to be static. And you find that in hundreds and hundreds and hundreds of cases all throughout the United States, and certainly there's many of them in the state of New York. Now, one of the sequela of the fact that we bring suit in the common law courts is that we're not bringing suit in federal courts, because federal courts are essentially not common law courts. There's very little common law that's used in the federal courts. And so one main reason we do that is because we don't want judges, when they're looking to the arguments around changing personhood or broadening it so that it will bring in some non-human animals, or at least our plaintiffs, we want them to be looking at the law that they, meaning they and their predecessor judges, that they created. So we are essentially saying, you made the common law, now we want you to change the common law because of scientific advances in changing experience and change morality and public policy arguments that we think you will accept. So if we go into a federal court, we really can't make that argument to a judge. And a judge in a federal court will essentially be interpreting statutes, constitutions, international treaties. So if we're trying to have a non-human animal designated as a person, we're probably going to have to point to a statute or a treaty or a constitutional provision that says something about a, quote, person, unquote. But when you do that, the judge in a federal court is going to look to the legislative intent as to what the word person was intended to mean. And the judge is going to quickly determine that the legislature or whoever was involved in enacting the statute or the constitutional provision, the international treaty, they didn't intend to include non-human animals, certainly not our plaintiffs. And indeed, that's the reason when we bring suit in front of a common law court, in, say, as we've been doing in the state of New York, that we don't rely upon state statutes either, or state constitution, or federal constitution or federal statute, because you run into the same problem with a common law judge. We want the common law judges to be interpreting an inherently flexible common law that they made, not trying to look at the word person and then trying to figure out what the legislature or what the Constitutional Convention or whoever, what they meant when they used the word person. So we've had two examples. PETA has filed two lawsuits in the last 10 years. One of them was claiming that tilikum and other orcas were not persons, but were essentially slaves under the 13th Amendment. And so, as we thought it would do, the federal court looked at the history of the 13th Amendment and said, nobody talks about non-human animals, we're talking about human beings there. We're talking about black slaves. And so they got thrown out. I think similarly, they're struggling with a case in which they claim that a monkey who took a selfie in Indonesia is the author and can get a copyright on the photograph that the monkey took. So I have to agree is an incredibly cute monkey. And in fact, you can take out your phones and just put in monkey selfie, and you'll see this incredibly lovely, amazing picture, series of pictures that this monkey took of himself. But the problem is that what they're having to point to something in the Copyright Act, and whether it's the word author or something else, the court essentially will look at it and determine that it was unlikely that a monkey in Indonesia or anywhere was intended to be that kind of an author. So they lost that case, but they're up in the Ninth Circuit. I'd be the last person to say that I can predict what courts will do, ever, anywhere. But I predict that they're not going to win, for a similar reason that I'm talking about. So that's why we, number one, would stay out of the federal courts. Number two, we would stay out of ever asking a judge to interpret a statute or anything where the word person is written, except under a very narrow circumstance. So, and if I remember, I'll tell you what that narrow circumstance is. And if I don't, just yell out, narrow circumstance, and I hope I'll recall that. So that's the reason why we're using the common law. Now we move to the issue of habeas corpus. Why are we using a writ of habeas corpus? Because we can use any kind of cause of action that we want to use, and we have other kinds of causes of action, some of which we may use in the future, some of which we decided that we can't use. They really don't allow us to move forward or win. So a writ of habeas corpus means, or habeas corpus means, you have the body. It's called the Great Writ, and it is fundamental in the armamentarium of Anglo-American law. And the reason why it's fundamental is one of the reasons why we wanted to use it. One of the many reasons. Essentially, the writ of habeas corpus protects autonomy. If someone is being detained illegally and against her will, then someone can bring a writ of habeas corpus. And there's a lot of wonderful things about it. In fact, there's so many wonderful things about habeas corpus, I probably won't remember them all. But the ones I can remember, I'll start telling you. So one thing is that there's likely, at least in the state of New York right now, there's no problem with standing. And so those of us who litigate on behalf of non-human animals or the environment, oftentimes have problem with standing. If you look at the SJC or the federal courts, you'll notice I've been thrown out on standing many times over my sad career of standing. And so standing means that you have. Well, first of all, you have to be a legal person. You have to have the capacity to sue before you even get to the standing issue. Second of all, if the plaintiff is a legal person, then you move finally up to the issue of do you have standing, which means really were you injured by the defendant? Did the defendant injure you, and can the court remedy the problem? Now, the paradox is that human beings or human instruments, like corporations, we have personhood. We have the capacity to sue, but we oftentimes are not being injured. Non-human animals are all the time being injured in vast numbers and being really terribly injured. But the only way we can sue on their behalf is to claim successfully that the injury that they're suffering is somehow injuring us as well. And most of the time, or oftentimes, we fail to persuade a court to do that. And as the years have gone by, under Article 3, the U.S. Supreme Court has actually made the requirements tighter and tighter. Justice Scalia was certainly one of the folks who was kind of gleefully responsible for that. And so that's always a concern that we have. Now, on the other hand, a non-human animal, being terribly injured, but isn't a person. And so the court will never even get to the issue of standing because they really don't even have a capacity to sue. It's like if my chair sued somebody, the judge isn't going to look at whether the chair has been injured. First, the judge is going to think, this is a chair. And the chair doesn't have the capacity to sue, so they're probably going to throw you out on that ground. So humans have the capacity to sue but aren't being injured. Non-human animals are being injured but don't have the capacity to sue. So what we're looking for is a way of protecting non-human animals both by having a capacity to sue and by being injured. So that really limits our ability to successfully file suit on behalf of entities who are non-human animals who are really being injured. So one of the many beautiful things about a writ of habeas corpus is there's essentially no standing requirement. So at least there wasn't under the common law. What happened was that habeas corpus was understood as meaning that person A is being detained illegally and against person A's will by person B. Now, person B is highly unlikely to allow person A time off to go to court to seek a writ of habeas corpus. So virtually anyone can then, who realizes that person A is being held illegally and against her will, can then go into court on behalf of person A and seek a writ of habeas corpus and ask that the judge issue the habeas corpus against person B and bring person A into court, and we can all sit and talk about what the heck are you doing by detaining person A, and is it legal, and is it also against person A's will. And so that's why you generally don't have a standing problem, because the courts recognize that standing really doesn't make a whole lot of sense when you're trying to file suit on behalf of someone who's being detained. So there was a U.S. Supreme Court case that may or may not have cut back on that may or may not have required that person C who sought the writ of habeas corpus have some kind of a special or some kind of some sort of a special relationship with person A. And if that's true, that means someone who doesn't have any friends or family can just be enslaved the rest of her life. We never thought that made a whole lot of sense. But there are cases, for example, where someone sought, where law professors and religious leaders sought to bring a writ of habeas corpus in the Ninth Circuit on behalf of folks who are being detained at Guantanamo, and their case was thrown out on standing grounds because nobody had any kind of a special relationship with the person in Guantanamo. So that's not, we don't think, the law in the state of New York, at least, and probably not the common law generally. And the single time that has been brought up and the judge addressed the issue in our habeas corpus cases, the judge found that we indeed did have standing, or that there was not a standing requirement. Whatever it was, we were able to proceed. And I'm arguing two appeals on March 16th on behalf of the chimpanzee Tommy and the chimpanzee Kiko on March 16th in the First Department in Manhattan, and the issue of standing might proceed there. And because even though no one else has ever found we don't have standing, that doesn't mean the First Department, who's never dealt with the problem, might feel that it has an obligation to inquire as to whether essentially it has subject matter jurisdiction and whether we have standing. So I'm prepared then to note that the state of New York has a long history of allowing habeas corpus cases to be brought by people who had no relationship with the detainee at all. And this was especially in the antebellum period, where you had the American Anti-Slavery Society brought many habeas corpus lawsuits on behalf of people that they thought were being enslaved illegally in the state of New York. Oftentimes, where someone from the South, where they were slaves, they were brought by their master to the state of New York and might have sojourned for a day or a week, and someone would find out about them, and they would seek a habeas corpus on behalf of those slaves. So we have at least 3 cases from that time that are reported, but if you look into the unreported history, you know that the American Anti-Slavery Society, and particularly a black man named Louis Napoleon, regularly went into court. And one of the most famous cases was called Lemon versus People in 1860, where slaves had been brought in from, I think, Alabama on a ship, and they wanted to head to Texas, and they were put in someone's home, the home of someone we think was named Lemon. And so it was 8 slaves, and the folks in the American Anti-Slavery Society got wind of that. Louis Napoleon went and sought a writ of habeas corpus. And he not only did not know the names of the slaves, he didn't know anything about the slaves. He didn't know the number of the slaves. He wasn't exactly sure where they were, and he wasn't clear as to the name of the person who was detaining them. But the lawsuit went forward, and the slaves were ultimately freed. So New York has a really, really, I think, appropriate way of viewing, and has for a long time, of viewing the standing, if there is a standing requirement for habeas corpus. So that was just one of the reasons we chose both habeas corpus, and one of the reasons why we chose the state of New York. Now, we chose it for many other reasons too. For one thing, the rule of res judicata generally does not apply in habeas corpus cases. So res judicata would mean essentially the thing has been settled. For example, you and I might enter into a contract. I think you break the contract. I sue you for breaking the contract, and I lose. So then I say, well, I'll try again. I'll sue you again. And I'm going to keep suing you until I win. So the courts say, res judicata, the thing is settled, and you only really get one shot at it. Principles of res judicata are clearly not applicable, at least in the state of New York, to writs of habeas corpus, both because someone's fundamental right to not be enslaved is at stake, and also some courts see it as every day that they're enslaved, that they are, or they're being detained, is a new cause of action. So when the Nonhuman Rights Project decided to bring its cases, we understood that no one had ever done that before, and some of the judges, or perhaps all of the judges, might think that the case was kind of strange, and that they had never dealt with anything like that before. And so we thought that it was quite likely that either we in the Nonhuman Rights Project would make a mistake, or the judges would make a mistake, or everybody makes a mistake, and we would lose. And when we lost, we wanted the opportunity to see why we lost, and then try to fix it, and then file suit again. And if we lost, we might try to fix it and file suit again. We found one case in which some prisoner had sought 4 writs of habeas corpus, had lost each time, and on the 5th time he won, and he was released. So we wanted to be able to do that same thing. Similarly, there's not really a venue issue in New York with respect to habeas corpus either. That you can file suit, you can bring a habeas corpus action in front of any justice of the trial court. And what we then began to do was to see why we lost the case, and then not only bring the suit again, but bring it somewhere else, and where we thought we might have a better shot at winning. For one reason, New York has a court set up. I think there's probably 200 Supreme Courts, which are the trial courts in the state of New York. And then geographically, the appellate jurisdiction is set up into 4 districts. You know, the first is Manhattan, the second is Long Island, the third is really central New York, and the 4th is western New York. And so we ended up, for reasons I'll tell you why, filing our first lawsuits in the 2nd, 3rd, and 4th departments of the state of New York. And we quickly learned that the law may not be the same. And if the Court of Appeals has not really set it, which is the High Court, has not really set out the law for everyone, when you bring a novel case, judges react in novel ways, and they may not be consistent, at all. And in fact, in our cases, they were wildly inconsistent. We've been in front of 3 appellate courts. We've lost on 3 separate grounds, and none of the later courts have even acknowledged that they were previous decisions. They didn't try to they didn't try to distinguish them. They didn't try to agree with them. They simply ignored them. So if you read the case, you think that each of the 3 courts is seeing the case for the first time in the state of New York. And so we then begin to try to find out where we think the law of that department might be more favorable to us. So that is another reason why we use the writ of habeas corpus. Another reason is I alluded to the fact that it's a summary writ. So you move very quickly. When the court says when the court says it's a summary writ, they mean that we go in on a writ of habeas corpus, and the judge would probably order us in for the habeas corpus hearing within 24 hours, 48 hours, 72 hours, because someone's bodily liberty is at stake. Someone is being held against her will illegally. The courts want to deal with it immediately. So there's no discovery, there's no testimony. You simply file out affidavits. And so it's really fast. So we didn't see any reason why we should get entangled in a civil law case, which could take 1 or 2 or 3 or God knows how many years to finish, where we wanted to get to the issue of, was our non-human animal plaintiff a person or not? So if we can figure that out in 24 hours, then why do it for 5 years? So that's what we decided to do. In fact, some of our cases have taken, I don't know, an hour or two. We lost within an hour or two, because in this you can lose really fast, and so we have lost really fast, and that is. But we were expecting that. We were expecting to lose really fast, and in fact that's what we wanted. So, and in fact, to some degree, we've always been concerned. So far, we haven't had any really reason to be concerned, but we sometimes have been concerned that we might win in front of the lower court and nobody would appeal. And then we'd have 1 of 200 lower courts that ruled in our favor. And I guess theoretically, what we really want to do is lose in the Supreme Court, the low court, but win at the appellate level. Although, we really would take winning anywhere, but that hasn't happened yet. So, but we get closer, and closer and closer. So, I'm trying to think of anything else about the writ of habeas corpus. Affidavits. It's really quick. So in New York, the way the habeas corpus statute something just came in. Why? Let's see. There was something about. I want to tell you about another thing about the writ of habeas corpus. Anyway, there is a common law of habeas corpus in the state of New York, as there is virtually in every state, and there is usually a layer of procedure over it. So there was a common law procedure for the writ of habeas corpus, but each state has made its own procedure. And now I remember what I wanted to say. In the state of New York, it's the only state we've been able to find that has this unique procedure, is that you can go in and you can either seek a writ of habeas corpus under the habeas corpus statute and the common law, or you can seek an order to show cause. And so if you seek the writ of habeas corpus, you're asking that the judge order that the detained person be brought into court. If you seek the order to show cause, you're just asking that the detainer come into court and explain why he can detain that person. We did not want the chimpanzees brought into court. And so we did not seek a writ of habeas corpus. We sought an order to show cause. And that actually led to confusion, we think, amongst the courts, because there is a statute in the state of New York that says that if you go in on an ex parte order to show cause, and you can do that under the habeas corpus statute, that's something else. You can go in ex parte. And the judge refuses to issue it, there's no appeal that lies from that. So we went in on our first cases on ex parte writs of habeas corpus. The judge refused to issue it, which meant when the judge said, no, I'm not going to issue it, that was the end of the case. We just lost while we're standing in the clerk's office. We're standing in the courtroom on the very first hour or two. Then when we would go to an appellate court, the appellate court would say there's no appeal from the refusal to issue a writ of habeas corpus. There's no appeal from a denial or refusal to issue an order to show cause that was issued or asked to be issued ex parte. And we would say, I know, Judge, but there's one exception, and that's this statute, habeas corpus. But the judges would not accept that. And so I'll tell you about that a little bit later. And so then we have now talked about going in on a common law, writ of habeas corpus, in the state of New York. We actually looked at every state, Puerto Rico, the Virgin Islands, D.C., and 20 common law countries, England, Australia, South Africa, New Zealand, India, to look to see where we wanted to file these cases, because we didn't necessarily think that we had to file the cases in the U.S. And we would run 50 or 60 different legal issues through all those jurisdictions. And so at one point, I was supervising 70 people who were doing research on all of these things, and we had literally hundreds of memoranda just flooding in that would talk to us about all of these issues. And then my legal working group would meet, and we'd lock ourselves in a hotel in Manhattan for a weekend every 4 or 5 months, and just go through all of these memos and try to rank all the common law jurisdictions. And then it turned out on Easter Sunday of 2013, New York, came to the top. We decided where we were sitting in Times Square in a hotel. We decided the place where we were sitting, that was the state in which we wanted to file suit. And one of the reasons was because of the writ of habeas corpus. We really, really liked the way the courts talked about the writ of habeas corpus. And we really, really liked the way the courts talked about autonomy, which we thought could be a way that we might be able to persuade the courts to rule in our favor. They thought that autonomy, the courts thought that autonomy was an extraordinarily important common law value. And for example, in the 1980s, the courts ran into the situation where someone would be in a hospital and he or she was going to die unless they had emergency surgery or had to take medication, and they would refuse to do that. And so the hospital would go into court, and the court would say that we will not allow you to overrule the autonomy of the patient. And if she wants to die, then she'll die. And that her autonomy is more important to the state, essentially, than her life is. So we thought, okay, this is a really important common law value, maybe a supreme common law value in the state of New York, which would harmonize with something else we were doing, which is that we understood that what we were doing was novel. And we thought the judges would want to keep the amount of novelty down to a minimum. So we did not press on the judges our own legal ideas, any kind of novel legal theories. What we sought to do was to identify what the judges say they valued through their written judicial decisions, and then make our arguments in terms of the values and principles that they say that they firmly hold. So one of them, a very important one, was the idea of autonomy. And so that then goes to what happens after we bring our case in with respect to a writ of habeas corpus. The writ of habeas corpus itself is really the procedural device that gets us in front of the court. Then once we're there, the judge says, okay, so what? Why are we here? We say, well, we want our client to be a person who has a certain kind of fundamental right, and these are the reasons why we want to do that. And we looked at New York law, as we looked at a lot of other law, and we saw that that liberty and equality were two really important supreme common law values in the state of New York. And a liberty right is a non-comparative right, the kind of right to which you're entitled because you have a certain kind of a characteristic. But the important thing is you don't compare yourself to anyone else. You're either entitled to the right or not entitled to it based upon who you are. An equality right is a comparative right to which you are entitled if you are like someone else in a relevant way, like someone else who has the right in a relevant way. And of course, the issue is whether the way in which you're like them is relevant. As I tell my students, everyone is infinitely similar and infinitely different from every other person. And probably, it's probably the same way for a tree and me, but certainly another human being. So the judges can hear a lot of arguments, and the people on the other side are trying to show all the differences to justify chimpanzees not being persons, not having a right. We're trying to show all the similarities. And the judge and so one of the most important ones is that the other side will say, well, you're not human. That's the difference. That's the only one we care about. Are chimpanzees not human? And the rights bearer is. And we say, yeah, well, that's one of an infinite number of differences, but you can't make any kind of arguments as to why that should be a definitive difference. It's just a difference, and there are lots of other differences, and we show lots of similarities. And so the similarities that we're showing as a matter of equality is also related to the ones we show as a matter of liberty, which is we talk about autonomy. because we look to the court saying how much they value autonomy. And then we argue as a matter of liberty, and then to some degree as a matter of equality, that since autonomy is a supreme common law value, we, judge, have an autonomous plaintiff. He's not a human being, but he's autonomous. And what you value is autonomy, and he is an autonomous being. And the way we show that is we went out and we met we got all the chimpanzee, really the greatest chimpanzee cognitive scientists in the world from Japan and Sweden and Germany, Scotland, England, and the United States, who then filed 100 pages of affidavits that showed, indeed, that chimpanzees were autonomous beings, in great detail. Everything's up on our website. Whether we win, lose, or draw, everything is always up on our website, and you can see what we do. So we argue that we've shown that the chimpanzee is autonomous. And so as a matter of liberty, we argue that it is a sufficient, though not a necessary condition, for to be autonomous. In fact, autonomy, judge, is what's really protected by a writ of habeas corpus. So what the writ of habeas corpus protects is the autonomy that our chimpanzee plaintiff has. So that really is our liberty argument that we make. The equality argument we make is, first of all, we have to show that equality is a common law value. And there are very few common law equality cases in the state of New York. In fact, almost anywhere, because once the 14th Amendment was passed, people began to litigate under the 14th Amendment Equal Protection Clause and not under common law equality anymore. But there is a law review article by Chief Justice Kaye, who was the Chief Judge of the Court of Appeals of New York, that's now 25 years old, in which she talks about the two-way road that has developed, where constitutional law influences the development of the common law, and the common law influences the development of constitutional law. So we argue that as a matter of equality, that the New York common law should at least adopt the minimum rationale test of the 14th Amendment equal protection, that in order to draw a line, there has to at least be a rational means to a legitimate end. And then we argue that anyone who draws a line that excludes our chimpanzee client, it may be rational, but there's not a legitimate end. That we have argued in court that the state of New York, or any state, does not have a legitimate interest in arbitrarily imprisoning an autonomous being. That is, in a nutshell, is half of our equality argument. The other one is we looked at the case of Romer versus Evans, which is 1992 now, where Justice Kennedy was dealing with Amendment 2 of the Colorado Constitution, where it appeared that the way the court could read it is that the fine people of Colorado had simply stripped gay people of all their rights in the state of Colorado. And Justice Kennedy said that really taking away someone's rights based upon a single characteristic is a violation of the Equal Protection Clause. And we say, our chimpanzee has these characteristics. The only one that you don't like, or you may not like, is the fact that he's a chimpanzee. And that depriving him of all of his rights based on the single characteristic of his species, that he's a chimpanzee, when he otherwise has the qualities that you say you value, should be a violation of common law equality. So one of the reasons we chose chimpanzees was because we could have chose lots of non-human animals, and we're on the verge of filing a lawsuit on behalf of elephants, another one on behalf of potentially orcas, chimpanzees, other great apes, was because chimpanzees have been studied intensively, both in captivity and in the wild. And there is an immense amount known about chimpanzee cognition. And what is known shows that their cognition is quite similar to ours. And so we thought it'd be easier for the general public as well as judges to empathize with the cognition of chimpanzees, because it wasn't a real foreign cognition. It's a very human-like or similar sort of cognition. So it simply would be easier for them to understand that. Plus, we had an immense amount of evidence that we could bring in that would support the cognition that the chimpanzees already have. So there was a little bit less for elephants, somewhat less for orcas, so much less for gorillas. So we thought that we would start, at least as a factual basis, with the non-human animal who people really knew an immense amount about. And then we would move on to others that we would know a lot about, but just not as much as chimpanzees. So in the affidavits that we filed, I think we filed 8 of them, the scientists cite more than 400 articles that support their research. There's just a lot, and that certainly is not all that there is. So what we did was decide on Easter Sunday of 2013 that we would file suit in the state of New York, that our first client would be a chimpanzee. And we actually decided on the Saturday night, the day before Easter, to file suit on behalf of an elephant. And I thought, I stayed awake all night, and I finally said, I think it ought to be a chimpanzee. And we began to talk about that the following day, and we decided to file suit on behalf of chimpanzee. So we then went out to identify chimpanzees. We found 2 of them, Merlin and Reba, who were imprisoned in a roadside zoo in the Catskills. After we decided to sue on their behalf, what we did was to go out and find them, go out and see them, make sure they were there. Turns out Reba had died 3 weeks before, and
we'll just give folks a quick sec to clear out if they have to
sure.
Class, and we'll have another 15 more minutes to ask
Okay.
questions.
But before people head out, I just want anyone who's an HLS student here to know that the Salad Board is accepting applications. Take a look at the Blackboard. Also, take a look at...
And I'd like you to know that you text 52886 and type unlock if you wish to work with the Nonhuman Rights Project.
Okay, so yeah, any students who have class at 1.
Okay.
To head out.
We're just getting to the good part.
Flash math.
So when we got to the zoo, Reba had died, and a very depressed chimpanzee, Merlin, was there. And we decided to file a lawsuit in the first week of December of 2013. And so in September, we went to check again, and we found that Merlin had died the night before. And so that concerned us, for many, many reasons. So at that point, we decided that we would try to identify all the chimpanzees in the state of New York and simultaneously file lawsuits, habeas corpus lawsuits, on behalf of all of them. And so we did the best we could to find them, and we identified 6 more. And then we went to check them all out to make sure that they were actually there and that they were actually chimpanzees, because it turned out that we went to one roadside zoo that said they had a chimpanzee, and they didn't. They had a monkey, and they run a roadside zoo, but they don't know the difference between a chimpanzee and a monkey, which is just one of the reasons why I can't stand roadside zoos. So that brought us down to 5. And then those 5 are the ones that we decided to file suit on behalf of. And from west to east, there were Kiko and Charlie, who were chimpanzees who were at a place called the Primate Sanctuary, which is not a sanctuary. It's just a place that calls themselves a sanctuary. It is a cement storefront in Niagara Falls that's jammed with birds and primates, including 2 chimpanzees in a cage. So we decided that we'd sue on behalf of them. Charlie would also die before we were able to file our lawsuit. And you can go to the Primate Sanctuary, and then I would direct you to the picture, which I think is in the film about us, Unlocking the Cage, where you can see the 2 adults, the man and the woman, and Charlie and Kiko, all posing in identical tuxedos, for a photograph. That's another reason why I don't like some of these folks. And also, Charlie was known as Charlie the Karate Chimp. You can go onto Charlie's webpage and you can see that he was taught karate and how he would go into he would fight other humans who knew karate. So we didn't have any problems in seeking habeas corpus writ against these folks. So Charlie would die. Kiko was still there. We found Tommy, who was in in a cage, in an enclosure, in a huge warehouse on a used trailer lot in Johnstown, New York, which was just a very small place. So small, we kept going through it. We couldn't find where they were. And we're still in Johnstown. We have to go back and forth. We were able to find I actually had to call the trailer lot to say, where exactly are you? And was able to find them. You can see what happened when I went onto the used trailer lot and how we found Tommy. It's all on film. Then there was Hercules and Leo, who were two young chimpanzees who'd been taken from their parents in Louisiana 6 years before when they were 2 years old. Now they were 8 years old. And they had been used in these kind of grotesque experiments at Stony Brook. They were kept in the basement of a computer building. As far as we know, they never went outside. They never saw other chimpanzees, although there may have been some that were there at some time. They were kept in a cage, and they were brought in at the age of 2, and they finally were left at the age of 8 as a result of our lawsuits. And they were used not even for biomedical research, they were used to satisfy the curiosity of the Department of Anatomy, which noted that chimpanzees walk with a bent leg and humans walk with a straight leg. And so they would take 6 years of these chimpanzees' lives to do research on them to find out why that's so. How do we evolve walking with a straight leg? Which also involved, and this is one thing that really infuriated me, it involved putting them under general anesthesia almost every month, both of them. And so I've been under general anesthesia, and at least for me, it's an exceedingly unpleasant thing to wake up when I wake up. And those were the 4 chimpanzees we filed suit on behalf of. So you have Hercules and Leo, you have Tommy, and you have Kiko. And so we filed the first suit on behalf of Tommy in a small court out of Johnstown, Gloversville, right around that area, in a rural court. And the judge came out. He was really interested in what we're doing. We filed an 80-page memo. And we filed almost a 200-page petition for habeas corpus that included 100 pages of affidavits. He didn't read any of it before he came out. And then we had an interesting colloquy, which you can see the transcript. He was extremely sympathetic to us, but he made it clear that he wasn't going to say that a chimpanzee was a person within the meaning of the common law writ of habeas corpus. He said, what's happening to Tommy is terrible, and I'm here to help you do anything to get him out, but I'm not going to allow you to use a writ of habeas corpus. And then he helped us get our appeal squared away. I mean, he was really nice, but he wasn't going to do it. When I realized that he hadn't read anything, when at one point I said something about their cognition, and he said, "You can't do that. You need expert evidence." I said, "You have 100 pages of expert, affidavits in front of you." So the fact he didn't know that was a real hint that he hadn't read anything that we had given him. So that was when we lost within like an hour and a half. So we thought, okay, we'll appeal. Then we got into the car, we went to Niagara Falls, and we did the same thing again. That judge said, "I need time to read your stuff." So we thought we were getting somewhere. And then we had a telephone conference, an argument 5 days later, at which the judge said, and you can look at that transcript, that judge said, he was also very sympathetic and said, "I'm not going to be the one to take this leap of faith." And so we lost there. And then we flew over to Long Island, and we went to Riverhead, where they have the Supreme Court there. And that judge treated us the way that we had thought we'd be treated by everybody, which is that we never saw him. We just saw a piece of paper come out saying, "Get out of here, get out of my courtroom." So that was what we had always thought. You can see how disappointed we were when that happens. I think the film shows the moment when it comes out. So the film I'm talking about is Unlocking the Cage, a Penny Baker Hedges HBO film, where they followed us around for 4 years as we prepared for what was going on. And then every time they could get their cameras into a courtroom, they were there. So you can actually watch what happened. I think they filmed for about 400 hours. So you only get an hour and a half of it. So a lot went on. Then we started going to the appellate courts, and that's when things got really interesting for us. So the first appellate court we went to was Hercules and Leo. The judge just said, "Get out of here." Okay, so we appealed that, and when we appealed that, my local counsel, who's also a wonderful member of the Nonhuman Rights Project, Elizabeth Stein, she moved my admission pro hoc vice to the second department. It was denied on the grounds that they were just sua sponte going to throw our case out. They weren't going to hear the appeal without briefs and anything, just dismiss the case on the grounds that we didn't have the right to appeal from an ex parte request, a refusal to issue an ex parte order to show cause. And so we tried to, we filed a motion for reconsideration, in which we said, look at the habeas corpus statute. You're allowed to do this. They just say affirmed, and that's the end. So we say, we're going to get back to this some other day, but right now we have another case we want to go to. The first oral argument we had was in the third department with respect to Tommy's case. And that is the one that's been, it's both, we think, the kind of strangest decision and the one that I'm going to be really attacking on March 16th. In that case, the court found that Tommy was not entitled to habeas corpus relief because to be a person, you had to, in order to have the rights of a person, you had to be able to fulfill reciprocal duties and obligations. And Tommy couldn't do that because chimpanzees could not. So we had problems with like every sentence, including like and the that was in that opinion, because no common law English-speaking court had ever made such a ruling. It's not the law, and also the court, I think at the end, may have noticed that millions of New Yorkers had rights but were unable to engage in reciprocal duties and responsibilities. So they put a footnote in, literally a 2-sentence footnote, saying that's okay. This does not affect humans because humans collectively can shoulder duties and responsibilities, whatever that may possibly mean, and therefore all humans can do it, but nobody else can. So. When we started to take their case apart, we saw that they were primarily relying upon Black's Law Dictionary for how you define a person, and we couldn't understand why Black's Law Dictionary said what it did, and then cited 2 jurisprudential writers. When we actually went back and scrutinized the sources, we found that Black's Law Dictionary had gotten both of them entirely wrong, and that they actually both supported us. They just said, in order to be a person, you have to be able to shoulder duties and responsibilities. That's what the court said it said. But the original says duties or rights or responsibilities, not rights and responsibilities. So that a person, they said, needed to be able to have rights and responsibilities in order to be a person. But the two jurisprudential writers they cited said rights or duties, which was our entire argument. So we then went on to the next appellate court in the fourth department on behalf of Kiko, and they did not mention either of the previous courts. And what they said was that Tommy or Kiko could indeed be a person. We're going to assume without deciding that he's a person. Our problem is that you can't use a writ of habeas corpus. And the reason you can't use a writ of habeas corpus is in order to use it, you have to move the detainee from being detained to being unconditionally free, which was quite a surprise to us because that's not the law of New York. And also, we had a colloquy with the judge who had said that in oral argument, and I started just reciting all of the New York cases, just one after another, until the judge finally said, okay, we get it. And then that was the reason we lost, after I'd cited one case after another that said that was not true. And so the judge was we thought they were essentially saying, well, what, we have to throw Kiko out into Times Square, we get him out of the cage and throw him in Times Square, so that's okay. But we weren't doing that to Kiko. What we're doing is moving him to a place called Save the Chimps, where he would live on a 3 to 5 acre island with 25 other chimpanzees in South Florida. And the judges seemed to not see a real difference between living in a cage and living on a 5 acre island in South Florida with 25 other chimpanzees.
We just have the room till 1:15, so if you want to get questions.
I do want questions, so I'll leave out the case that we almost won in front of Justice Jaffe, which is really how the film ends, where in that case in the Supreme Court, Justice Jaffe essentially agreed with everything we said, but felt that she was bound by that person, the rights or responsibilities, as opposed to rights and responsibilities, that she was bound by them. And even though and she said tellingly, I think, that a court is bound by the decisions of a higher court, even when they don't agree with it. Okay, let me...
So we are going to have time for only one question.
I am so sorry.
It's fine.
I'm so sorry.
So does any student have a question that they wanted to ask Steve?
Well, we didn't need all that time.
I just want to quickly
Okay.
add that the
Yeah.
film is available on demand on HBO, and also anyone who's a Harvard affiliate can go into Canopy, Canopy with a K.
Is it on there?
Yeah, and if you just sign in with your HUID login, you should be able to watch it, download and watch it. It's on Unlocking the Cage.
It's that's where we get, if you want to be involved at all with the Non-Human Rights Project, if you text that, put in unlock, that's where we got unlock, then this is just beginning today, so I really don't exactly know what happens when you hit unlock. But I hear that they'll ask you some questions about whether you want to be involved with the Non-Human Rights Project. So the film did premiere at Sundance in 2016, and it's been playing at film festivals and theaters around the world. It's been shown on the BBC in England, in Denmark, in Sweden, in Germany, in France, and lots of other places. In fact, they're showing it in Abu Dhabi. I'll be there. I'm leaving tomorrow for Abu Dhabi. They're showing it on Monday, where I'll talk about the film there. And I'll think, I'd rather be in Cambridge.
So given the interest of time, can everyone please give Steve another round of applause for coming out and speaking?